All right, everyone, welcome to your first lecture on question answer discussion. Don't worry, students, even if you were not able to answer all the questions, or maybe you didn't know what to write. This is the first time that you're attempting the questions. Give yourself some time. Okay. After going through the lectures, I'm very sure that now you have confidence as far as the concept is concerned. Now we just need to know how to apply those concepts in the question. I will teach you how much to write, what to write, how to frame the answer. Just give yourself some time. Okay? All right. Now, how are you supposed to attempt these questions? I don't want you to write each and every answer in your notebook. Okay, I'm not expecting you to write everything in your notebook. But yeah, you can choose any 5 questions and answer them completely. So this will give you an idea of what to write, how much to write, what should be the length, etc. Now, how to use this compiler? If you notice, students, there is gap. Okay, there is a lot of space. There is a lot of place here in the left hand margin. Now this is how I used to write and prepare when I was studying for CA. I used to make use of the left hand margin. I used to use it a lot to write keywords, then important points, small notes of mine, etc. So that is the same technique which I have used over here. I have kept the left column blank. Now you will use this to write pointers. You will frame your answer. You will write the points on which you will elaborate if this question is asked in the exam. So make use of the left hand margin. The answers in my compiler, they are in this 4-step format: provisions, facts, analysis, conclusion. So this will give you an idea of what to write, how much to write, and what should be included in provisions and analysis, because this is how you're supposed to attempt the answers in the exam. All right, students. So let us go through the first question, and that will give you an idea of how to use the compiler to the best of your advantage. The first question is a very direct, straightforward question testing you on the concept. All contracts are agreements, but all agreements are not contracts. Do you agree with this statement? They want you to comment on it. Now, if you are a student and you need to frame the answer, what all points will you mention in this answer? Let's make a note of those points in the left margin. What all will you comment on? Firstly, you will define agreement. Now, agreement is defined under section 2, clause E. Agreement means when a promise and a set of promises forming consideration for each other is an agreement. So you need to define the agreement. Ma'am, why are we defining agreement? Why are we defining contract? That is because the question is a direct question. That is why you need to define it. You will not define agreement and contract in each and every question. Okay. Now, every question asked from this chapter will be based on contract only. So you need not define it. This is just a very basic, simple question testing your knowledge. That is why we are defining it. How did I know that we need to define agreement? We need to define contract. See, these two words are mentioned in the question, and the entire answer is based on their definition. So this is a hint that you need to first define these terms. So what is an agreement? What is a contract? We will define that first because these two terms are mentioned in the question. Agreement means it means every promise and every set of promises forming consideration for each other is an agreement. Now, we will also after this write the equation of agreement. Okay, we will also write the equation of agreement. So agreement is nothing but offer plus acceptance. After this, write the definition of contract. Now, contract is defined under section 2, clause H. Okay, contract is defined under section 2, clause H. You will also write, what is a contract? An agreement enforceable by law. Correct. We will also write the equation of contract. What is the equation of contract? What is the equation? So contract is nothing but agreement plus enforceability. Can I say that from this itself we have concluded that every contract is an agreement, but every agreement is not a contract. What is missing? Enforceability. In an agreement, there is no enforceability. So that is the key difference between agreement and contract. That is what distinguishes agreement from contract. Enforceability is the only reason that all agreements are not contracts, but all contracts are definitely agreements. So all contracts are agreements because to form a valid contract, we need offer and acceptance. But all agreements are not contract because the element of enforceability is missing. Because we have also mentioned enforceability, you need to now elaborate on the concept of enforceability. You will elaborate enforceability. So you need to mention something about social or domestic agreements. There is no enforceability. Yes, in case of social or domestic, there is no enforceability. We presume, there is no presumption. Okay, we presume, we don't, there is a presumption that parties do not intend to create legal relation. There's no enforceability. However, in case of business or commercial transactions, we presume that there is enforceability. Okay, so there is a presumption that in case of social or domestic agreements, there is no enforceability, but in case of business or commercial, there is enforceability. So you need to elaborate on enforceability. You can also give examples. Give examples of agreement and contract. Give examples of agreement and contract. So this will create good length in your answer. So what all points have you included? You defined agreement. You mentioned the equation of agreement. You defined contract. You mentioned the equation. Enforceability is what distinguishes agreement from contract. So you have elaborated enforceability. In case of social domestic, there is a presumption that parties do not intend to create legal relation. In case of business or commercial, we presume that there is enforceability. Then we will give examples of agreement and contract. I think this much content is sufficient for a 4 to 5 mark question. Now, agreement comes into existence when one party makes a proposal or offer to the other party and the other party accepts it, gives his consent. So agreement is nothing but offer plus acceptance. Yes. A contract is, however, an agreement enforceable by law. Did you notice that they have started by writing the definition of agreement and contract? And how did I identify that I need to start with the definition? Because the concept asked in the question is based on agreement and contract. So that is the entire basis of the question. It means that to become a contract, there must be legal obligation, that it must be a duty enforceable by law. Can I say that they are now discussing about enforceability? Yes. In case of social, moral, religious, we assume that there is no enforceability. But in case of business or commercial, yes, there is enforceability. In fact, agreement is a very wide term than contract, because in contract we include only those agreements which are enforceable by law. Whereas agreement includes everything, enforceable as well as not enforceable by law. All agreements are not contracts, but all contracts are always agreement. So there must be intention to create legal relation. Only then it will become a contract. Otherwise, it is just an agreement. For a contract, there must be two things. We need agreement and we need enforceability. So agreement is the prerequisite of contract. Prerequisite means you cannot form a contract without any agreement. You need an agreement to become a contract. So that is the first step. So it is true when we say that all contracts are agreements. We can say that there can be an agreement without becoming a contract, but we cannot have a contract without an agreement. It is the same thing, but they have just mentioned it in different ways. So you can write it in your own words. If this is asked as a 4-mark question, most of the marks will be for writing the definition and equation of agreement and contract, explaining enforceability, and I would also like you to memorize and learn this paragraph. Okay, learn this paragraph. So if it is a 4-mark question, 2 marks, 2 marks, 2 marks for writing definition of agreement, contract, enforceability, and 2 marks for writing this paragraph. You will have to learn it. Don't expect you to know all these points in the first lecture itself. We have just started with the question answer discussion. Okay. Now, next question is a case based question. You will divide your answer into 4 parts. In provisions, we will write the section number, name of case law if any, and only theory. In facts, you will explain the question in brief, okay, very briefly. In analysis, write down solution, arrive at the solution. You can write a few facts and then you can also mention the solution. In conclusion, you will start with hence, therefore. I had discussed all this in my last lecture. So you will start with so, hence, therefore, it is so concluded. From the above, we can conclude that. Basically, the last part of the question will be answered in conclusion. Okay, answer this question in conclusion. Let's read the question. A sends an offer to B to sell a second-hand car for 1,40,000 with a condition that if B does not reply within 1 week, A will treat as if the offer is accepted. Is A correct in his position? Ma'am, we have a doubt in this question. The answer is silence does not amount to acceptance. But can we also answer this question as offer must not contain a term, the non-compliance of which amounts to acceptance? Yes, you can answer it from the point of view of offer also. So is A correct? That if I hear no more, if you do not reply within 1 week, I will assume that the offer is accepted. Offer must not contain a term, the non-compliance of which amounts to acceptance. Or you can also say silence does not amount to acceptance. It's the same. So here they have answered it from the point of view of acceptance. Acceptance must be communicated. You can communicate by words, by action. Okay, either by words or action. I'm highlighting the keywords. So silence does not amount to acceptance. Acceptance must be communicated. How will you communicate? See, the next sentence can be derived from the first sentence itself. See, it must be communicated. How will it be communicated? Either by words or by action. You need not elaborate. Words can be oral, written, action. No need to elaborate. Just mention the point. Acceptance cannot be implied from silence. You can write over here. Silence does not amount to acceptance. Okay, silence does not amount to acceptance. Acceptance must be properly communicated. Silence does not amount to acceptance. Acceptance must be communicated. Okay, so these are my key points. Unless, the offeree by his previous conduct has indicated that silence does amount to acceptance. Okay, do you remember the example of magazine? We had discussed that the magazine, yes, was that A had subscribed. Let me write it over here. A had subscribed for a magazine for 1 year, but the magazine continued to be sent for 5 years. After 5 years, the company gave him the invoice and he says, why should I pay for 5 years? But you have used the services. No, you did not cancel it. Your silence in this case amounted to acceptance. So there was an exception. So if you have forgotten to write this right now, it is okay, but you please remember it for the main exam. So over here, basically, we need to write about silence does not amount to acceptance. Acceptance must be properly communicated. Communication may be either by words or action. Sometimes silence does amount to acceptance. If by previous conduct we have given an impression that silence is acceptance. In the given case, A offers to sell his car to B on the condition that if B... Now here I cannot write it in my own words because the question itself is of 2 sentences. So what will I write? In fact, it is just 1 sentence. So I will write this only in facts. Analysis. Now, if B remains silent, that does not amount to acceptance. Again, silence is not acceptance. So even if B, now you're offering solution. See, in the first paragraph, we only mentioned the theory. We did not write anything about A giving an offer to B. What were his conditions? We did not mention anything. We only created a background. We only mentioned the theory. But yes, in analysis, we will now offer solution. So now give references to A, B, give solution in this in the analysis part. So over here, silence does not amount to acceptance. So if B remains silent, that is not acceptance. Acceptance must be made within a prescribed time. Okay. Acceptance after the prescribed time will not be valid and the offer will lapse. So in this case, you cannot say that if the reply is not received, then I will assume that it is accepted. That silence does not amount to acceptance. So is A correct in his proposition? Answer is no. A is not correct in his proposition. Ma'am, can we write the answer? No, A is not. Students, never start the answer with no. Okay? Never start your sentence with yes or no. Hence, A is not correct in his proposition. Okay? So don't start your sentence with yes, A is correct. Yeah, A is no, A is not correct. Don't start with yes or no. Please write over here alternate solution. Alternate solution. What is the alternate solution? If you have written offer must not contain a term, the non-compliance of which amounts to acceptance, that is also correct. So write over here. Alternate solution is that offer must not contain a term, the non-compliance of which amounts to acceptance. Okay, so offer must not contain a term, the non-compliance of which amounts to acceptance. If this is asked, it will mostly be asked as a 4-mark question, but can also be asked for 3 marks. There is very less content. So provisions will carry a weightage of 2 marks. Analysis 1 mark. Or maybe 1.5 mark. So let me write 1.5 mark. And half mark for conclusion. Ma'am, you have not given any marks for facts of the case. I never give marks for facts because it is just writing the question in your own words. There is no application of concept. You're just copying the question. Ma'am, then why are we writing it? It's just a paper presentation, answer presentation. Yeah. So it is just a presentation format. So over here, it is just a presentation format, but no marks will be given for facts. All right. Next, I hope you are writing along with me. Yes. Don't feel lazy and take a photograph that will remain in your mobile only. Please pause the video, write all this so that it helps you to revise the concept. Okay. Next, let us discuss the third question. Question 3. Explain the type of contracts. A coolie in a uniform picks up the luggage of A to be carried out of the railway station. We had discussed this as an example. Without being asked by A, and A also allows him to do so. Now, in this case, the coolie, by picking up the luggage, is giving an offer. Words are not used. Then what kind of offer is it? It's an implied offer. See, while reading the question, you should start framing the answer. So yes, this is nothing but implied offer. A allows him to do so. This is implied acceptance. He does not object. His action shows that this is implied acceptance. What does it become? It becomes an implied contract. Implied means it is understood from our action, section 9. Section 9 discusses implied contract. So you need to write everything about implied contract. So will this be a valid contract? Yes, it is a valid contract. Implied contracts, they come into existence by implication. It means they are formed by other than words. Words are not used. It is understood from our action, conduct. It may be implied by law. Parties never intended to enter into contract, but law says that there's a contract. See, we need to first explain what is an implied contract, and then we will discuss that yes, how these provisions are applicable to our situation. So first explain what is an implied contract. So contracts, they come into existence by implication. So most often it is implied by law or by action. Section 9 of the Indian Contract Act, it contemplates that when words are not used, but it is made otherwise than in words by action or conduct, then a promise is implied. Now in the present case, okay, wait, this is actually explaining what is implied contract. Okay, this explains an implied contract. Now, can we write this in provisions, facts, analysis? Why aren't we following that format here? Because in case a question is asked on this, it will be only for 2 marks. Okay, if a question is asked, it will be for 2 marks. So I don't think you need to write. Now this will be of 2 marks, 2 marks. So I don't think that you need to write a lot. You don't need to follow the format because it will be asked only for 2 marks. So in this case, we will first explain implied contract. In the present case, the coolie, by picking up the luggage, okay, the coolie, by picking up the luggage, has given an implied offer. A also allows him to do so. This is implied acceptance. What becomes is an implied contract. There is a contract. Therefore, A must pay for it. Students, even though we have not given the heading like provisions, facts, but the flow is the same. This is provision. We have written the theory first. Then we have explained, we have given our analysis. The coolie picks up the luggage. This is implied offer. We allow him, A allows him to do so. This is implied acceptance. It becomes an implied contract. This is conclusion, that if there is a contract, it's implied, then you have to pay for it. So flow is the same. Only thing is that they have not written the head points because it's just for 2 marks. Next we have obligation of finder of goods. X found a diamond ring at the birthday party of Y. He asked everyone, who does it belong? Nobody owned it. He kept it with himself. Does it mean that he has become the owner? He's just a finder. He's a caretaker. It is implied by law that you have to take care of the goods and try to find the true owner. Once the true owner is found, you have to return the ring back to him. This is implied by law. So it's actually called as a quasi-contract. If you remember, I had discussed this in the form of a chart with you. This is a quasi-contract. What is the meaning of quasi? Quasi means it is just like a contract. Okay, it is just like a contract. These are known as like contracts. Okay, quasi-contract, they are known as like contracts. So obligation of finder, caretaker. He is not the owner. It is just like like a contract. You need to find the true owner, return the goods to him. Let's read the answer. This is a quasi-contract. A quasi-contract is, let us highlight the keywords. It's not an actual contract. It only resembles a contract. I want you to write this in your answer. Ma'am, but we have not discussed it in such detail. We will be studying this in unit 6. So for the exam, you will be knowing quasi-contract in detail. So don't worry. Even if now you say that, ma'am, these are new words for us. Don't worry. You will anyways know this concept in the end when we discuss it in unit 6, quasi and contingent contracts. It is created by law under certain circumstances. It is created by law. This is implied by law. Implied by law means it is created by law. Parties never intended to contract. There is no offer. There is no acceptance. It is just implied. It is just created by law. Law says that the circumstances are such that this is a contract. It enforces certain legal rights and obligations when there is no real contract. There is no offer. See, there is no offer. There is no acceptance. There is no offer. There is no acceptance. But even then, an obligation is imposed that you have found the goods. Take care of the goods. Try to find the true owner. These are known as quasi-contracts. It is a contract where we never had an intention to enter, but law imposes a contract upon the parties. Ma'am, these words are slightly difficult to remember. Don't worry, you can write this in your own words. Just include the key points. Okay, so here the key words are that it is not an actual contract. It just resembles a contract. It is not a real contract. There is no intention, but it is imposed by law. Okay, so it is imposed by law. So yes, this is a contract. It's a quasi-contract. So is it a contract? Yes, it is a contract. A contracts with B, the owner of a factory, for supply of 10 tons of sugar. But before the supply is effective, the fire caught the factory and everything was destroyed. Now A contracts with the owner of a factory for supply of 10 tons, but before the supply is made. All right, just wait. He has contracted. It means a valid contract comes into existence. But later on, due to certain circumstances, in my case, fire, everything was destroyed. It means the contract becomes void. Everything was destroyed. So before the contract, the supply is effective. It means before we perform, everything is destroyed. The contract becomes void. Okay. So here you will write about void contract. It's a void contract. Section 2 clause J defines a void contract. You will write the definition because there is nothing much to write. A contract which ceases to be enforceable by law becomes void. When does it become void? When it ceases to be enforceable. Okay, so a contract, it means it was valid when entered, which ceases means stops being enforceable by law. There is some circumstance because of which it ceases to be enforceable by law. Then it becomes void. When does it become void? When it ceases to be enforceable. So this only discusses the time when it becomes void. So void is one which is not enforceable by law. They have written whatever they could about a void contract because there is nothing much to write. So we wrote the definition. We wrote that it is not enforceable by law. Ma'am, can we write this point first? Yes, you can write this point first, just how we wrote it in the notes. Void means it is not enforceable by law. Then you will write the definition. Ma'am, what if in the exam we have just written that it is a void contract, but we have not explained this? But for 2 marks, you need to write the explanation. What if we wrote wrong section number, but the definition is correct? That's okay. Only half mark may be deducted, but definition is correct. You will get marks. You get stepwise marking. You will not get 0. Okay. So here you need to write that it is a void contract. You need to write void means it is not enforceable by law. You need to write the definition. So 3 points are sufficient for a 4-mark question. I will also consider the section number as 1 point on the basis of which we will give you marks. Okay. So yes, you need to write that also. Next, Shambhu Dayal started a self-service system in his shop very frequently. Please highlight this as important for exam. Students, I am very happy to share with you that most of the times the questions that we mark as important for exam are asked in the exam. So I don't want to boast, but whenever I give a list of important questions, most of them are asked in the exam. It's just years of experience. Okay. So this is important for exam. It may be asked, they will twist and turn some, they may change the wordings, but the concept remains the same. Again, very important for exam, the difference between offer and V means versus, offer and invitation to offer. So this is very important for exam, offer and invitation to offer. So you need to know this concept. If in the model answer you feel that offer versus invitation to offer, the wordings are very confusing, forget it. Just write the content from my textbook. Okay, so you can these provisions you will find in my textbook. It is not compulsory that you write this exactly as it is given in the module, as it is given in the compiler. Compiler is model answer given by ICAI. This is to give you an answer what they expect. But if you feel, ma'am, these wordings are slightly confusing for us, your notes are very easy. I agree. My notes are very easy to remember. So you can write this from my notes. That is textbook. You can write from my textbook. Okay. You can write this from my textbook. Provisions, you can write it from my textbook. Now, Shambhu Dayal started a self-service system. Srimati Prakash entered the shop, took the basket. After taking the articles, she reached the cashier for payment. Cashier refused. Can the cashier refuse, or can Shambhu Dayal be compelled? Decide as per the provisions. Now see, can Shambhu Dayal be compelled? They have asked you a question. You will answer this in conclusion. Okay, so answer in conclusion. They have asked you a question. Now, whatever is on display, is it offer or is it invitation to offer? See, display, please write this, okay? Display is simply invitation to offer. Here, Srimati Prakash, by putting the goods in the basket, has given the offer, which can be either accepted or rejected by Shambhu Dayal. So the point of acceptance is here. Okay. Now, display is an invitation to offer. Srimati Prakash has given the offer, which can be accepted or rejected by Shambhu Dayal. In this case, he refused to sell. Okay, yes, he refused to sell and accept the price. Can he refuse? Yes. It is his choice whether he wants to accept or reject the offer. So display is only invitation. So here basically you need to explain offer and invitation to offer. So what is an offer? Offer is very definite. It can be accepted or rejected immediately. It is expression of final willingness to contract, whereas invitation to offer comes before a definite offer. It invites offer from the other person. It is basically inviting negotiations from the other person. So 6 points for offer and invitation to offer. 3 points for offer, 3 for invitation to offer. Also, you have to compulsorily mention the name of this case law, Pharmaceutical Society of Great Britain versus Boots Cash Chemist Southern Limited. Why am I insisting on mentioning the name? Because this question is a direct conversion of case law into question. The facts are very similar to the case law. If I am the examiner and you don't write the name of this case law, I will deduct your marks. Half mark if you have written. Now you need to pay attention to the spellings. You need to pay attention to how it is written. So in this case, explain offer and invitation to offer. Explain the case law. This you can write in analysis. Okay, this you need not write here. This you can write in analysis. Okay, here. All right. So name of the case law is important. That we will shift to analysis. So first in provisions, I will explain offer and invitation to offer. 3 points, I will write 3 sentences. I will write explaining offer and 3 sentences explaining invitation to offer. You can write it from my textbook. Write the name of the case law, Pharmaceutical Society of Great Britain versus Boots Cash Chemist Southern Limited. In fact, you will just explain the question in your own words. In analysis, you will now start explaining display. Okay, display of articles with price in a self-service shop. No need to write all this. Simply if you write the display is merely an invitation to offer. In this case, Srimati Prakash, by selecting the articles and approaching the cashier, is an offer. If the cashier does not accept, the interested buyer cannot compel him to do so. The point of acceptance is with the cashier. It is the decision of the cashier whether he wants to accept or reject the offer, whether he wants to accept or not. So from the above, we can conclude that. See how we start the conclusion. What are the wording? Hence, from the above, we conclude that. Yes, do you please note all this? I had given it in the last lecture. Hence, so, therefore, from the above, we can conclude that. This is how you will start conclusion. The display is merely an invitation to offer. The customer, by selecting the goods, puts them in the basket. This is offer to the cashier. The offer can either be accepted or rejected by the cashier. He cannot be compelled to sell the articles to the customer. What was the question asked? Can Shambhu Dayal be compelled to sell the said articles? Can he be compelled? So these are the exact words which I have written in the conclusion also. No, he cannot be compelled. Okay, he cannot. Ma'am, we have a doubt over here. What if we write all this in analysis? What if we write this in analysis? And what if we have written only this one sentence in conclusion? Is it correct? Yes, of course it is correct. So it is up to you. Acha, one more point. I have already written it over here. This is just a kind of repetition. It is allowed. If you notice, more or less, these words match. But we need to create length of the answer. This, therefore, I have written in conclusion. Okay. So this is how we have framed the answer. This is correct. If you have written it that way, it is correct. This will be asked as a 4 to 5 mark question. If I am the examiner, I will give half mark for writing the case law. I will give 2.5 mark for writing the theory. So I'll just write it with some different ink. So half mark, then 2.5 mark. So this comes to 3 marks, 1 mark 4 and 1 mark 5. Okay. Why am I giving more marks to provisions? Because you may write some more sometimes. Okay. 1 mark for this. This is how I would grade you. Just check if you have written everything properly. Yes. Done with the note making. Okay. State whether there is a contract in the following. A engages B to do certain work and remuneration will be paid as fixed by C. Fine. A engages B to do a certain work. There are two parties. Remuneration will be paid as fixed by C. There is consideration. There are two parties. It's a valid contract. It's a valid express contract. Ma'am, we have only written valid. Is it correct? It's fine. A and B, they promise to pay for the studies of their maid's son, but they are not getting anything in return, no? It's just a social contract. It's just a social agreement. It's not a contract. It's just a social agreement. A takes a seat in the public bus. Bus is implied offer. A takes a seat. This is implied acceptance. What becomes is an implied contract. Okay, it is an implied contract. So it's an implied contract. You can also write section 9. Institute has not written section 9, but we can write what is the implication. It means because it is a contract, A is now bound to pay for the bus fare. A chartered accountant, promises to help his friend to file a return. Again, this is social agreement. It is social without any intention to create legal relation. There is no enforceability. This is not a valid contract. Okay. It's not a valid contract. If this is asked, it will be for 1 mark each. So that is why one or maximum 2 sentences are sufficient. Question 6. Miss Shakuntala puts an application to be a teacher in a school. She was appointed by the trust of the school. Her friend who works in the same school informs her about the appointment informally. It means without any authority. But later, due to some internal reasons, her appointment was cancelled. Can Miss Shakuntala claim for damages? Very similar to Powell versus Lee. Yes, very similar to the case law Powell versus Lee, because this is an exact conversion of the case law. You need to write the facts also in your own words. So what will you write? Yes, what will be your content? What have you thought of something? What all have you thought? Yes, you will mention the case law Powell versus Lee, and you also need to explain the facts and judgment in your own words. Okay, you need to mention it in your own words. Now, what does Powell versus Lee relate to? Which concept is covered? Acceptance must be communicated either by the offeree or authorized person. Very good. So it is important that you mention the essential element to which it relates. Acceptance must be communicated either by the offeree or an authorized person. So this is very important. Now this communication may be either in words or action. Even if you have not written this now, it is okay. But you need to mention that acceptance is complete only when it is communicated either to the offer or either by the offeree or authorized person. You will then explain the case Powell versus Lee. You need to mention the facts and the judgment in your own words. So this is actually explaining the entire case law. Then we will write facts of the case. Now, what will be the analysis? Can Miss Shakuntala claim damages? Answer is no. What is the reason? Since the acceptance was not communicated by the authorized person, it is not valid acceptance. There is no contract, so there is no question of damages. In the given case, Shakuntala's friend did not have the authority to inform Shakuntala about her appointment. The school authorities also never authorized that person. They never authorized. The school authorities never put the acceptance in the course of transmission. Now, why have they written this? See, we discussed earlier that communication. Okay, we discussed that communication must be either by the offeree or authorized person. Okay, we discussed that it must be either by the offeree or authorized person. Here the offeree are the school authorities. Yes, offeree are the school authorities, and authorized person, there is no authorized person. So neither did the school authorities specify nor did the authorized person specify. Okay, they had not even authorized someone. So in this case, Shakuntala's friend did not have the authority, and also the school authorities never put this. So neither the offeree, so school authorities are the offeree. So neither the offeree nor any authorized person communicated the acceptance. Therefore, acceptance is not valid. Okay, acceptance is not valid. Miss Shakuntala cannot claim damages. So here my conclusion will be that you cannot claim damages as it was neither communicated by the school nor authorized person. Why have we mentioned both? Why have we mentioned both? Because the provision requires the communication to be done either by the offeree or authorized person. Here neither the school nor the authorized person communicated the acceptance. Therefore, acceptance is not valid. See, sometimes it happens that while studying the concept, we may have not paid more attention to this. I had explained, but yes, there is so much to learn that maybe you must have missed this concept. But see the advantage. Through these questions, you are now able to remember and understand the theory better. Don't you think that you now understood this concept better just because you applied the concept? This is the advantage of solving questions. All right, let us continue. Mr. Ramaswamy, very important question for exam. Please highlight this as important. You need to go through this question one day before the exam. Okay, go through this question one day before the exam. All right. Now, Mr. Ramaswamy proposed to sell his house to Mr. Ramanathan. So Ramaswamy is the seller. I always prefer identifying the parties first, whether who is the buyer, who is the seller, because this helps to understand the question better, and I'm able to frame the solution in my mind because I know the parties, I know what is happening. So Mr. Ramaswamy proposed to sell his house to Ramanathan. Ramaswamy is the seller, Ramanathan is the proposed buyer. Ramanathan sent his acceptance by post. All right, so the acceptance is sent by post. Next day, Ramanathan sends a telegram withdrawing his acceptance. Yes, revocation should always be a faster means of communication. Examine the validity if the telegram of revocation was received by Ramaswamy before the letter of acceptance was received. Actually, the main purpose of revocation, sending it by faster means, is that it should be received before receiving the letter of revocation, the letter of acceptance. So I think that the revocation is valid because it is received before the letter of acceptance. Now, what should you write? Do you remember we had discussed communication of offer and acceptance, and there we had also studied provisions relating to revocation. So in the theory, you will write everything related to revocation. Okay, write everything related to revocation. So revocation of acceptance should be revocation of acceptance should be done before the letter of acceptance is received by the offerer. As far as the person who's revoking is concerned, as soon as he puts the letter of or telegram of revocation, for him communication is complete. As far as the other party is concerned, the revocation is complete when he receives it. So you need to write everything about revocation. Communication of acceptance is complete as against the acceptor when it comes to the knowledge of the proposer. So first they have written about communication of acceptance. So communication of acceptance is complete as against the acceptor when it comes to the knowledge of the proposer. Ma'am, why have they written communication is complete as against the acceptor over here? See, because he is revoking his acceptance, right? So we need to see when is communication of acceptance complete for him. When is he bound by the contract? Because he can revoke only before he is bound by the contract. So Ramanathan is bound by the acceptance when it reaches the seller, Ramaswamy. So he must ensure that his revocation reaches before the letter of acceptance. So in this case, the communication of acceptance is complete when, I think they have just written the theory. We don't need to write so much. Communication of acceptance is complete as against the proposer when it is put in the course of transmission. So something about communication has been written here. So communication of acceptance. I always prefer referring my notes because I had given it to you properly. That communication of acceptance is complete as against the proposer when it is put in the course of transmission. Yes. Do you remember? We had taken the dates 5th April, 7th, 8th April, 10th April. So as soon as the letter is posted, it is put in the course of transmission, we can say that the proposer is bound. As against the acceptor, can we write in this manner in the exam? Yes, you may write it. It is complete when it comes to the knowledge of proposer. Okay, so when he receives it, that is 10th of April. Then they have written about communication. Okay, communication of revocation. Now, this will tell us the content that we need to write. So, communication of acceptance is complete as against both the parties, that we have written. Communication of revocation. So what theory do we need to write over here? The theory that we need to write is when is the communication of acceptance complete and when is the communication of revocation complete. Okay, so these are the two theory parts, provisions that you need to write. As far as revocation is concerned, for the person who's making it as soon as he puts it in the course of transmission, and for the other person, the revocation is complete when he comes to know about it. In the given case, yes, now let us answer. Is the revocation valid? Yes, the revocation is very much valid because it was received before he received the letter of acceptance. What if the telegram of revocation and the letter of acceptance both reach together? We had discussed this. It's a matter of chance. It's a contract by chance. If the letter of revocation, if the letter of acceptance is opened first, then a valid contract is created. But logically speaking, a rational person will open the telegram first. So if the telegram is opened first, then the acceptance is revoked. It is not a valid contract. But if the letter of acceptance is opened first, then it is a valid contract. So whether a contract is formed or not depends upon whichever is opened first. If Ramaswamy opens the telegram first, as a rational person would, then the acceptance is revoked. But if he opens the letter first, then a valid contract is already concluded. Revocation is not possible. So please read this answer again. What are the points that they have covered? Communication of acceptance, communication of revocation. Over here, they have answered both separately. Now, please pay attention, students. Because the question has two sub-questions, A and B, your answer should also be in the same manner, A and B, okay? Because there are two sub-questions, your answer is also in the same manner. Don't write small 1, small 2. Don't change that, okay? Father promised to pay his son 1 lakh rupees if the son passed the examination in the first attempt. Now, son passed the exam. Father failed to pay. As soon as you read father and son, it should click in your mind that this is a domestic agreement. Okay. So what will you write? This is a domestic agreement. In case of domestic agreement, we presume that there is no enforceability. You can also write that there is no intention to create legal relation. I think that will be better, no? No intention to create legal relation. But should we directly start by writing that there is no intention to create legal relation in case of domestic? I don't think that it is fair to just start your answer directly. Let's build up the provision. So let us write the definition of contract. Then let us explain enforceability. In that, let us explain something about business, commercial, there is presumption. But in case of social or domestic, there is no such presumption. Let us build the answer. I think that will be better. So definition of contract, explain enforceability, write something about domestic agreement, that there is no such presumption. Which case law can we mention here? If you had thought of Balfour versus Balfour, I am very impressed. Very good, students. Okay, Balfour versus Balfour. So you will write definition of contract, you will explain enforceability, domestic agreement, you will write about that. You will state the case law, Balfour versus Balfour. All this should be written in the provisions. As per section 2 clause H, this is the section wherein contract is defined. Okay, this is the definition of contract. Contract is an agreement which is enforceable by law. What is enforceability? Intention to create legal relation. In case of social or domestic, we assume that there is no enforceability. Case law, Balfour versus Balfour. Here they have explained the facts. Okay, they have explained the facts because there is not much to write in the answer. So you can decide and explain. There are also students who prefer writing the case law by giving a separate heading as reference case law. So after provisions, Okay, you can include reference case law, write Balfour versus Balfour. So this will be like a separate heading only. Balfour versus Balfour. Okay. And then you will write the facts and judgment. Okay, write the facts and judgment. This is a domestic agreement. We presume that parties do not intend to create legal relation. Therefore, son cannot recover the promised amount from father. We assume that in domestic agreement, there is no legally binding agreement. You can also write that parties do not intend to create legal relation. You can write that also. So applying the above provisions, son will not be able to claim, they will not be able to recover the amount from father. So we will not be able to recover the amount from father. How did I find the conclusion? State with reasons whether son can recover. Okay, state with reasons whether son can recover. So because they have asked this in the end, you will answer this in the conclusion. Always note, students, that the last part asks you a question and that question will be answered in conclusion. So this we will answer in the conclusions part. Okay, all right. You can pause the video anytime and take down notes. X's brother runs away from the house. Okay, Y, who is his employee, offers to search for him and he goes out. In the absence of Y, X offers a reward of 500. Okay, he declares 500 as reward. But in the absence of Y, now this is very important. It gives us a hint that Y was not aware of the reward. Okay, this implies, you can write it here. This implies that Y was not aware of offer, of reward. See, this is a clear hint. This is a clear hint that if he is not aware of the reward, if the offer is not communicated, he cannot claim the reward. You cannot accept the offer in ignorance of the offer. Case law. Tell me, which case law have you mentioned here? Have you thought of a case law? It is Lalman Shukla versus Gauri Dutt. Yes. So Lalman Shukla versus Gauri Dutt. This is name of the case law. Do we need to explain the case? It is your wish. You can explain the case because this is a direct conversion of the case into a question. So you can explain it. Now, what else will you write in the provision? You will first write that offer must be communicated. What are the provisions that we had studied over here? That offer must be communicated. Only when the other party knows about the offer, he can accept it. A person cannot accept an offer if he is unaware of the existence. Offer must be properly communicated either by words or by action. An acceptance in ignorance of the offer is a nullity that will not create a legal obligation. Nullity, it means it has no legal effect. Having no legal effect. It is a nullity having no legal effect. Ma'am, what if we have not written this? We forgot or we were not aware. Don't worry, this is practice ground. Now, if you study and learn it, you will remember it for exam. It's a very good sentence. Acceptance in ignorance of the offer is a nullity. It will not create any legal obligation. As per Lalman Shukla versus Gauri Dutt, we need to mention this case. Because it is a direct conversion of the case, I would appreciate if you explain the case in your own words. So write the case law and the judgment in your own words. Since Y was unaware of the offer, he could not accept it. Acceptance in ignorance is a nullity. It does not create any legal obligation. This is the solution. See, over here in the first paragraph, I did not mention anything about the question. I only wrote offer must be communicated. I explained that provision. I explained case law. If you write all this, you will easily be able to write one page of answer. This, if asked, will be for a 4 to 5 mark question. If I am the examiner, I would give 2 marks. for writing the introduction. I would give 1 mark, let's say 1 mark for writing the case law, half mark for writing the name properly. This is 2, 3, 3.5. This is 4.5 and 5. Okay. So this is how I would have given you marks. Based on the above, we conclude that Y cannot claim the reward. How did I know what is to be written in conclusion? Can Y claim the reward? This was asked. I answered this over here. Can Y claim the reward? Y cannot claim the reward. Do you remember I had also mentioned that although they don't want you to write the reason, but I always prefer writing it. Y cannot claim the reward because he was not aware of the reward. He was not aware of the offer. So if you continue writing one small line of reason, I would really appreciate that. Okay. Define offer and explain the essentials of a valid offer. How is offer different from invitation? Now, students, this is mentioned in the model answer by ICAI, but I feel these are not the essential elements. In fact, these are rules of offer. So, according to me, ICAI has given the wrong answer. Please write essentials from my textbook. If you read offer versus invitation to offer answer over here, ICAI has given the answer which is slightly confusing. Please don't refer this. You can write offer versus invitation to offer from my textbook. Okay. Now, I don't think I need to show that to you again and again, but sometimes students forget. So these are my lecture notes. When I go through this, that time I realize that we take down so many notes in the class. There's so much of writing that we do, right? Okay, so I had discussed offer and invitation to offer. You can write this. If you feel that whatever is given in the module is confusing, so you can copy this theory. You can write this theory from my notes. Okay, it is acceptable. A shopkeeper displayed a pair of dress, 2000 rupees price tag was attached. Lovely looked at the cash tag and rushed to the cash counter. Very similar to the previous case that we discussed. It's a repeat question. Pharmaceutical Society of Great Britain versus Boots Cash Chemist. It's the same. It's a repeat question. So you will explain offer and invitation to offer. Okay, you will explain offer and invitation. Please write the case law. Explain the case law. Mention the name. Write the spelling correctly. Explain the facts. Price tag. Okay, the tag which is display is just an invitation to offer. The customer has given the offer, which can be either accepted or rejected by the offeree, that is the cashier. So here she cannot sue the shopkeeper. What was the question asked? Can he enforce the cashier? Can he force the cashier? No, you cannot force the cashier. Very similar. Important for exam. Please learn this properly. Acceptance must be absolute and unqualified. Yes, we had discussed this. Acceptance must be absolute and unqualified. Acceptance must be a mirror image of the offer. Acceptance must be a mirror image of the offer. You must accept the offer as it is without any variation, reservation. If any reservation is made or any condition is imposed, then it is just a counter offer. Counter offer does not amount to acceptance. It's a new offer altogether. Also write example. Now this is again just a theory question. It's just a theory question. So you can write this from my textbook. Please write and explain the example. Don't write it in arrow format. Write in sentence format. Acceptance must be in the prescribed mode. Do you remember we had discussed this in the form of a chart? Acceptance must be in the prescribed mode. If the mode is specified, then acceptance must be in that mode. Yes, I had given you this chart. Acceptance must be in the mode specified. So I have specified that I want by courier. What if he sends by regular post? Then you can either reject or accept that other mode. If he is rejecting, rejection must be within a reasonable time. If he is accepting, then later on he cannot cancel. You just have to write that in theory. So it is again covered in my textbook. If this is asked in the exam, it will be for 2 marks each. For 2 marks, or if it is asked for 3 marks, there is a lot of content to write. Please write examples. This will add a lot of length to your answer. But if it is of 3 marks, no need to write a lot. I will tell you how much length is to be written. Last question. State the various modes of revocation of the offer. This is again a theory question. You will give the heading. You will explain it. You will leave a line. Again give the heading. Explain, leave a line. And so on. This will be asked for 6 to 7 marks. No need to write examples. There is a lot of content. 1 or 2 examples you can give if you feel you don't know. You don't have much to write. You can give examples. Like see here I have given examples. But I have not given example in all the provisions. Yes. Okay. There are 2 more. I thought that is the last question. My mistake. Explain the types of contracts in the following cases. Will be asked for 2 marks or 1 mark. Okay. It depends. Nothing is fixed as such. 1 or 2 marks. X promises to sell his scooter to Y for rupees 1 lakh. However, the consent of Y has been procured at gunpoint. Coercion. Very good. Is this a valid contract? No, it's a voidable contract. It's a voidable contract. Coercion is used. So here, the contract is voidable. It is obtained by coercion. You can either treat it as valid or cancel. Okay. A bought goods from B in 2015, but no payment was made till 2019. We have not studied this concept till now. Just write over here time bar debt. You will understand this when we come to Unit 2 consideration. Just write for now. I'm not discussing it now. We will discuss it later. G agrees to give tuitions to H, a pre-engineering students, from next month. H agrees to pay from next month. Both will perform their obligation in the future. This is an executory contract. This is an executory contract. So both will perform their obligation in the future because both have to still carry out their obligation. This is an executory contract. Reason also they have given because both have to still perform their obligation. Mr. Asim, you will go through this question one day before the exam. It is important. Asim is an advocate. His car was stolen. He gave an advertisement in the newspaper. Please note, students, advertisement in the newspaper is general offer. I will give reward of 10,000 to whoever finds the car. This is a general offer. Vikram reads the advertisement. It means he now has knowledge of the offer. See how I am framing my answer? General offer means an offer which is made to the public in general. Anyone who has knowledge of the offer can accept it. And on making some efforts, he got the information. Asim found his car, but he denied giving the reward of 10,000 to Vikram. He says that an advertisement in the newspaper is just an invitation to offer. It's not an offer at all. He is not liable. State with reasons whether Vikram can claim the reward. Is this an invitation to offer? It's offer. So again, we will explain what is offer. What is invitation to offer? Did you notice that this concept has been asked many times in the exam? Advertisement in the newspaper, you will write all this. Advertisement in the newspaper is just an offer. In fact, it's a general offer. General offer can be accepted by anyone having knowledge of the offer. So you have to write all this. Explain general offer. Explain who can accept it. It's made to the public in general. Anyone who has knowledge, he comes forward, acts accordingly. That is acceptance. So in the first paragraph, we wrote everything about offer, invitation to offer, general offer. It can be accepted by anyone who having knowledge, comes forward and acts accordingly. Here, Asim's offer is a general offer. Mr. Vikram read the advertisement. He had knowledge of the offer. He found the car. He came forward. He acted accordingly. Finding the car. This is implied acceptance. Finding the car is implied acceptance. So Asim's offer. What am I doing? Yes. Asim's offer is a general offer. It is accepted. He finds the car. It is acceptance. There is a contract. Mr. Asim is liable to pay 10,000 to Vikram. This is my solution. On the basis of above provisions and facts. So I had mentioned earlier, your conclusion will start with so, hence, therefore. From the above, we conclude that. On the basis of the above provisions and facts, we can conclude. On the basis of our discussion, we can conclude. So somehow you will try to end the answer. Very important concept, offer versus invitation to offer. Now please note that if you are asked a 2-mark question, okay, if the question is for 2 mark, write 4 sentences. It is enough. For 3-mark question, write 4 to 6 sentences. 6 is ideal. It's a 4-mark question. Half to 3/4 page. Also depends on content, your handwriting. 5-mark question. 3/4 page to 1 page. 1 page means 1 side, okay? 3/4 side of page. 1 side. 6-mark question. 1 page to 1.5. 7-mark question. 2 pages, 2 sides to 2.5 sides. Here you can also, for 6 marks, sometimes you may also extend to 2 sides of page. Okay, 2 sides. There is a lot of content if it is a 6 to 7 mark. This is not prescribed by the institute. It is my recommendation. Okay, this is my recommendation. Okay. So students, with this we come to an end of today's session. This is how we are going to discuss question and answers for each and every unit. I will be discussing with you the pointers, the key points, head points, how to frame the answer, how is the marking scheme like. Please share this with your friends. Lectures are available on my website, capreetyagarwal.com. You will find the description, you will find the link in the description also. Okay, so please share this with your friends. And let's proceed to the next unit, wherein first we will understand the concept of consideration, and then again we will meet for question answer discussion from my compiler. I'll see you there.